Hi, Don and Shaw here again with yet another case I just recently came across. It's a matter of some interest here. It's called U.S.C. Levy, L-E-V-Y, 137 Fed 2nd, 778. And this was the case where this poor guy got convicted for willfully and unlawfully maintaining possession of his gold and silver coin without a license. Who the hell needs a license for that? His attorney, quote unquote, was just about as good as Daryl Starworth was in the case I'm working on now. Didn't raise any serious issues here. I mean, Jesus. So it starts out, and I'm not going to read the whole thing, but it starts out, it says, Levy was convicted of unlawfully, willfully, and knowingly holding in his possession gold bullion in violation of Executive Order number 6260, issued by Franklin D. Roosevelt about a week after the bastard gets into office. Now, wait a minute. Since when do we make law by executive orders? When and how does that happen? Think about it. Don't we have a Congress that's supposed to do that? Damn, nowhere in sight here. So, appellant Levy was convicted by a jury, quote unquote jury, under an indictment charging a willful and knowing possession and retention of an interest in gold bullion without a license in violation of this Executive Order 1933, issued by FDR, pursuant to Section 2 of the Emergency Banking Relief Act of March 5th, 1933, on the heels of HJR 192, House Joint Resolution against the public policy of the United States to pay debts. Damn. Goes on, talks about how he got apprehended. It goes on, prior contradictory statements of both appellant and Stellman, the attorney, are intended to show that appellant was engaging in an independent venture as sole owner of the gold. The jury was then clearly justified in finding that he held the gold willfully and knowingly without a license. And the appellant indeed does not now contest the conclusiveness of this finding. And he sure as hell had been. Should have been. How can you find him in willful and knowing possession when even if he's aware that this executive order is issued, there are affirmative defenses here his attorney should have presented at the time? And I'm not sure in this context. This is about the cutoff time for me. I know when my mom was in school in this time frame, they got a much better education than what I got, and sure as hell what we're getting nowadays. Even then, however, you might not have known of the existence. Now, that's why they say we publish it in the public register. You're supposed to know. Public register laws are only about 10,000 pages, for crying out loud. So that issue never got here. And he never challenges it. And he never challenged the verdict of the jury, and should have been doing that. Wait a minute. In fact, he should have had his own jury instructions like I have on willfulness, and like you'll get by acquiring my document packets, youwinnincourt@gmail.com. And I'll send you information about getting those. And we instruct the jury. And by the way, the jury instructions right now are about 575. In the near future, it's going to be over 600. And any of you that acquire materials now will get any additional instructions and all new documents or change documents for a year if you acquire the entire packet. So there's going to be a lot more to go with this now. But that said, we get back to the case here. It says the appellant's first point is the statutory power of the president to prohibit hoarding of gold bullion did not authorize regulations requiring delivery of such bullion to government representation. That the power requires delivery was given to the Secretary of the Treasury by another statute carrying only a civil and not criminal penalty. Even then, they're on thin ice. But my goodness. It goes on, and it said denial of the injunctions were affirmed by the appeals court, and it says the Act of March 1933 was an amendment of 5B of the Trading with the Enemy Act of 1917, which the bastards still use today, that they think makes you and my cameraman and everybody else undocumented enemy aliens. This is the factual foundation and legal basis. And we are, because with the state of war that occurred with the war between the states, which I personally think is still in existence, We are, and I've got some case law on that you'll get with my materials too. Undocumented enemy alien. That's what they think they are, and I'm now challenging the Attorney General, whoever the hell it is this week, to file and go before a grand jury and get me indicted for being one of those, and send me to Gitmo, and we'll see who walks out of there. Family's been here since Light Horse Harry Lee in the 1780s, and I'm an undocumented enemy alien. Could you explain that, please? That's what they think. The Act provides that during the time of war or during any other period of national emergency declared by the President, who apparently has unfettered discretion to do that, as noted, by the way, by the essays on emergency powers 40 years later in 1974, or 30 years from the time of this case. And the Senate was complaining then that the United States had been in a perpetual state of one or another emergencies for 40 years pursuant to this power. We're complaining about it. But that's one of the bonus documents you get for asking for my materials is this report by the Senate of the United States, document 93-549. You read this one, and you realize 45 years later we're not only in the same situation, it's worse. Perpetual state of emergency. But I don't see how a quote-unquote emergency would be anywhere close, because the Constitution of the United States, Article 1, Section 9, Clause 2, writ of habeas corpus cannot be suspended except in cases of rebellion or invasion. Not state of emergency. Rebellion or invasion. They can't do it, and yet it's done. Just happened in the Oakland case. They do it all the time without overtly doing it. But if you're not going to hear the writ, they're suspending it. I don't see how they get away with that. I really don't. And so it goes on. And it says here, it was generally understood when the executive order was issued that gold bullion included gold in a form containing various degrees of base metal. Very minimum degree would be, and you wouldn't even maybe know you had it, and you would still be guilty of it. Damn. Error assigned to the refusal of the court, to give requested instructions to the jury that appellant must have acted willfully and knowingly is likewise without merit or intent, since the court charged by its own language that a willful intent was an essential ingredient of the crime. What the hell is that? Essential element, and yet willfulness is not defined. Jeez, what they're doing to us now, they don't define this in any of their statutes, and they can't prove it. Because if they're sitting there without authority, and we have affirmative defenses to say, wait just a damn minute here, we have no valid government in the state of California at all, and we don't, not a Republican form of government pursuant to Article 4, Section 4, ask that question instead of anything with that BS 14th Amendment. You get a much better result there. Nothing remotely resembling a Republican form of government. And here, the plaintiff here, in the criminal cases especially, the people of the state of California, I challenge any of my viewers to look at the Constitution that they think is currently in effect now from 1879. See if you can find the people of the state of California mentioned anywhere in there. I can't. Who the hell are they? We don't know. Now, the good news about this, a little aside here, but it's important for you to know this, because I have documentary evidence now from a friend in Southern California that asked the Secretary of State, is this Constitution still in effect? 1849, the original one. They said, yes, it was, and it is. I did the same thing. They didn't reply to me, but the absence of a reply to my certified mail communication says the same thing. Now, look at the Constitution of 1849. What do you see? Article 2, Section 1. People of the state of California, free, white, male, 21. End of story. By the way, on this subject, I had the California Supreme Court, thank God, a long time before Tawny was ever on there, saying in the case of Van Valkenburg v. Brown, 43 Cal 43, 1872, after the ratification of the 14th War Amendment, that no white person owed their citizenship to the recently adopted amendment. That's the name of that tune. State citizens still exist. We still have status. And in California, we have a judicial court that we should be able to reach, called the District Court under Article 6, Section 1 and 10 of the Constitution of 1849. we get into that court with all this BS they put us through in the, the traffic courts and criminal courts and tax courts. Now we have a free ticket out because we have status and standing in a judicial court to which they can't even enter unless we let them. And I don't know about you, but I'm not planning on letting them come in there. They've already committed multiple acts of deceit, fraud, and treason, and whatever standing they might have had, they don't have now. And we can raise all of these issues under Articles 1 through 6 of the Constitution, and they're going to have nowhere to go. Simple as that. So like I said, send me an email at uwinnincourt@gmail.com. You'll get my document package. You'll read it for yourself. There's nothing hard about it. It takes a little time and study on your part. No question about it. There's no magic documents here. Although I might have if you when this Oakland case gets settled. But you have to do a little work on your own. It's not your fault they didn't teach you in school either. And you can also teach your kids so that they're going to know even if they don't learn in grades 1 through 12, and they're not going to, but they'll be way far ahead of the people that don't know and know how to deal with things and take better care of their life and get the government off their backs. It's exactly where we want them to be right now. There's no government there to start with. So I get a little carried away, but the point is, that's what I'm saying here with this Levy case. And by the way, this bastard Homer Cummings, who was then the Attorney General under FDR, said about, this law exactly, that he wouldn't mind making a few examples of people who refused to turn in their gold and silver coin. And this is what they did in this case. He didn't prosecute this one, to be sure, but it was done with his approval. And also, to be sure, by the way, what they weren't requiring people to do was to turn in, if you were a coin collector like I am, and I don't have hardly anything in gold now, but at the time, if you had coins, gold or silver, they were collectible coins and worth money, you didn't have to turn them in. But of course, most of the people at that time weren't from my part of the country in Virginia and West by gosh, Virginia. Now, were they? Couldn't afford to have coin collections. The New York banksters on Wall Street could. Just a thought. Just a thought. So this is the first case, and send me the email at uwinnincourt@gmail.com. I'll send you this excerpt I have from this Levy case. You can read it for yourself. Have to have a license to have gold and silver coin. What the hell is next? By the way, the legal definition of license from Black's Fourth Law Dictionary, legal definition, what they use, license, permission granted by competent authority to do an act that would be illegal, a trespass or a thwart. That's what they think it is. You need their permission. And yet we created all government and they're our agents and we need their permission? Yeah, right. Try to get that one past the jury when I'm involved in the case. That ain't going to work. And you can be in the same situation. You tell them the same thing I did. We don't need a license for any purpose whatsoever with this government. There'll be things where you might need with the proper lawful government in place. Okay, that's one thing. In fact, for me, I'm so damn old, by the way, that my mom told me when she got her first pair of glasses at the age of 7, she got them from a traveling optometrist who went from town to town, didn't have a license, didn't nothing. But he examined her and got glasses, and she wore them. She was nearsighted like I am, not this nearsighted, but, just somebody without a license didn't need one at that time. This is in the 1920s. You just didn't need a license to carry on an occupation. We had a right to do that. And we got a decision of the 9 farts that I don't know off the top of my head, Murdoch v. Pennsylvania, where they said right in there that, the government can't convert a right into a privilege. So send me an email about that, uwinnincourt@gmail. I'll get you that case. I just don't have that one off the top of my head in particular. But Murdoch v. Pennsylvania, you can Google it. It'll probably pop up too. But I agree with that. It was a 14th Amendment case. But nevertheless, the court understands that. You just can't go around doing that, especially in a legislature in which we are not represented. And in California, we're not. We got 40 million people here. We got 80 members of the Assembly, meaning that the racial representation is 500,000 to 1. That's not even close to a Republican form of government, and we'll discuss that in another video. But trust me, there's a real problem they have there in Sacramento with that. No representation. No consent of the governed. That's how we beat the bastards. So that said, like my videos, subscribe, tell other people, and we will go from there. Thank you.